Jason mentioned a couple of times that there's some type of similarity between federal spending and regulation and the costs of regulation. Here's what it is. As with federal budgeting, when the federal government regulates, it is allocating resources. The difference is most of the resources that are being allocated through most regulations are things that never appear in the federal budget because regulation by its nature tells us what we must do, what we may do, what we can do, what we cannot do. So it's more like conscription, okay? Just as back when we had the military draft, the full cost of running the military did not appear in the federal budget because we had the draft, which was acquiring talent at below market rates. The reason you had to have a draft is because the government wasn't paying a market rate for folks who were pulled into the military. Similarly, with regulation, you have a lot of costs that are not part of the federal budget because they are not expenditures. Federal expenditures to devise, write, implement, and enforce regulations are just the icing on the tip of the iceberg. And my favorite example of this is with something we're probably all familiar with if you've ever ridden on an airplane, airport security screening post 9/11. The numbers here come out of some work that we did right after 9/11 when security screening was ramping up. That's why it's numbers from 2005. But what really matters is the concepts. And that is, you have an explicit cost that is in the federal budget, which is the budget for the Transportation Security Administration to pay for the equipment, to pay for the screeners. But that is by far not the only cost that society bears in order to have safer air travel. Another big chunk of time is, well, similar to conscription, people wait longer in airports in order to get through security as a result of enhanced security procedures. And at least in 2005, some economists did a ballpark estimate that the value of additional time that people were spending waiting in airports was a couple of $2 billion, almost half of the explicit federal appropriation. In addition, because of the increased hassle, a lot of people decided to reduce the amount of traveling they did by air, and that cost the airline something, revenue loss of a couple of $1 billion. Plus, you have some other things. There were a group of economists at Cornell who looked at the way that people substituted modes of travel in response to enhanced airport security. And one of the things people did, heck, I did it, said the heck with it, for a short trip, I'm going to drive instead of fly. Well, statistically, driving on highways, interstate highways, is much more dangerous than flying on an airplane. So you also had an increase in fatalities that you could put some kind of monetary value on. So the vast majority of the resources that are allocated through most regulations are usually not resources that are in the federal budget. They're private resources that have some kind of a cost, some kind of an opportunity cost. They could have been used for something else. Well, if decision makers are going to allocate resources, what should they know? And I say this very generally, because what I'm going to show you, this logic really applies to government decisions about spending, government decisions about regulation, and also decisions, at least big decisions in our private lives as well. What kind of things would you need to know in order to make pretty significant decisions that involve allocating pretty significant resources? Well, you want to know what you're trying to achieve, the desired outcome, and what kind of problem are you trying to solve in order to get that outcome. You want to look at alternatives. You want to know about the social benefits. This is certainly in the case of government policy. What are the benefits that are conveyed on everybody in society, and what are all the costs shouldered by everybody in society as a result of each of these alternatives? And then after it is implemented, you want to know, how are we going to track progress? How will we know that the regulation actually achieved the intended goal? What kind of goals and measures are we going to have, and how are we going to check? Now, this matters, you would do this for regulation. This is similar to, I would say, how folks ought to think about federal spending as well. This is really just the rational policy analysis method applied to regulation and to other things. I have a daughter who's looking at colleges right now, and we go through a pretty similar process. And it's very interesting to see what kind of look you get when you ask colleges, how do you know what kind of value you're adding? How do you know that you are actually doing something other than just being good at picking students who are going to be successful? And you go to different places, and I'll tell you, you get everything from really good answers to a deer in the headlights look, because they never really thought they'd have to justify that. And sometimes in this town, you get the deer in the headlights look when you ask this question as well. Well, Jason walked you through the budget process. I'm going to show you how some of these things affect the federal regulatory process. So you get 2 death marches for the price of 1 at this event, the budget process and the regulatory process. Regulation starts with a law authorizing the regulation. Congress passes the law, and there is no institutionalized system that ensures that Congress has the kinds of information that I listed that folks ought to have in order to make big decisions. The analysis really starts once the action starts in the executive branch. I'll show you independent agencies in a minute. It's similar. But you have some analysis done in the executive branch that's required by executive orders. You have the Office of Management and Budget reviewing the regulation and the accompanying analysis. Then you have the notice of proposed rulemaking. You get public comment. The agency revises the regulation, revises its analysis of the regulation, passes that through the Office of Information and Regulatory Affairs again to get approval to publish it as a final regulation, and then the final regulation is published. Next, Congress may get into the act again if it decides to vote to overturn the rule. There is no institutionalized requirement for analysis to inform this decision, except for a provision in the law that makes the Government Accountability Office responsible for collecting whatever information on costs and benefits the agency produced. The rule may be challenged in court, but courts don't particularly do original economic analysis, and in many cases, I'd say in most cases, most challenges to rules are not based on the economic analysis the agency did. They're based on other legal things. Was it within the scope of the law, the authority granted by the enabling statute, that kind of thing. Unless there is some specific special circumstance where the economic analysis mattered to the agency's decision, it's usually not in play in courts. Happens occasionally, but not often. And then the final rule takes effect. So the only analysis we get of the really big important questions, when it happens at all, happens in the agencies. But that happens for a very small slice of regulations. The federal government adopts 3,000 to 4,000 new regulations every year. Only 60 to 100 of those are considered economically significant, where some type of a full analysis of the problem, the alternatives, and the benefits and the costs is required by the executive order. And through our work in the Regulatory Report Card Project, evaluating the quality of these analyses over the past 6 years, we've found that even for those 60 to 100 regulations, the analysis is often missing information, missing pieces. I've seen a lot of them that if I were grading them according to the criteria that OMB says they ought to be following, it would be the equivalent of an F. So we have a handful of regulations that receive some analysis that's often incomplete. Now that's in the executive branch. In the independent agencies, the regulatory process is very similar, except you don't have the review of regulations by OMB, and you don't have analysis requirements imposed by the executive order, because no president has attempted to apply the executive order on regulatory analysis to independent agencies. Some legal scholars argue that presidents could do this, but no administration has wanted to pick that fight since 1980. So we have no analysis that occurs in independent agencies as a result of executive orders. Occasionally, there may be some statutory requirements for some type of analysis, but it's usually somewhat fragmentary. Here are the main ones. All agencies have to comply with the Paperwork Reduction Act, figuring out the paperwork burden of their regulations. But the paperwork burden is typically only a very small part of the cost of regulations. All agencies are supposed to determine whether the regulation will have a disproportionate effect on small businesses and do some analysis of the effects on small businesses and maybe look at alternatives that would reduce the burden on small businesses. That is certainly not a full-blown analysis of the effects of regulation on all of society. That's just a look at small business effects. And finally, in certain cases, there might be specific legislative requirements for specific agencies operating under specific pieces of their legislative authority, where the agency is either supposed to conduct a benefit cost analysis of its proposed regulation or consider benefits and costs. My old agency, the Federal Trade Commission, had a more explicit requirement for certain types of regulations. The agency had to produce a benefit cost analysis. There are other agencies that are required to consider benefits and costs, and what they are actually requiring to do kind of depends on how courts have interpreted the statute. So the Securities and Exchange Commission has language in its authorizing statute that said when it's determining whether regulations are in the public interest, it must consider the effects on competition, efficiency, and capital formation, and the DC Circuit has interpreted that to mean that the agency, the commission, needs to consider the benefits and costs of alternatives. On the other hand, for some reason, the Commodity Futures Trading Commission, which has language in its statute that said it must consider benefits and costs, has somehow managed to get court decisions that say just because they have to consider benefits and costs doesn't mean they have to do analysis of benefits and costs. I'm just telling you what happens. I'm not trying to explain why it happens. For both independent agencies and executive branch agencies, we have relatively weak enforcement of whatever analytical requirements exist. We've done a lot of research at the Mercator Center on the effects of OIRA review on the quality of analysis that agencies produce, and we found that it makes a difference. OIRA review, there is evidence that OIRA review makes agency regulatory analysis better and makes agencies more likely to explain how they use the analysis in their decisions. But the end result that we still get is still a lot of analyses that are pretty incomplete. So it's better with OIRA than it would be without OIRA, but it still isn't where you would expect it to be if you actually read the requirements for regulatory analysis that are in the executive order and in OMB guidance. When we look at the influence of any kind of economic or regulatory analysis in Congress, when Congress is considering legislation that would authorize regulations, there might be some, but there's no real organized, institutionalized way to ensure that there's some kind of independent analysis of the underlying problem and the benefits and costs of alternatives before Congress passes a law, or after Congress passes a law to see what happens, to see whether the law achieved its intended effects. And finally, the judiciary, as I mentioned earlier, it's involved in enforcing some statutory requirements. The statutory requirements are often somewhat vague, somewhat weak, and it's all reviewed under what's known as the arbitrary and capricious standard, which prompts the judiciary to give agency judgment a lot of deference. So if an agency can articulate a reason for not doing a very good analysis, that will often, but not always, but often be enough to trigger pretty substantial judicial deference to the agency's judgment. Oh, on the back end, yeah, there isn't much analysis of the actual results of regulations either. There's really no organized process for Congress that ensures that Congress has information on the actual results of regulation when it looks at, say, reauthorizing agencies or reauthorizing regulatory statutes. Administrations, every administration, at least since Ronald Reagan and possibly earlier, has had some kind of ad hoc initiative urging agencies to try to find regulations that they could eliminate or revise, things that are duplicative, things that are outmoded. And typically those initiatives focus not so much on retrospective evaluation of effects. Typically they focus on finding things that are just sort of clearly outdated and silly. And those kind of initiatives do some good. We're better off with those initiatives than without them. But that's a far cry from any kind of systematic culture of going back and examining the results of regulation to see what actually happened. Dr. Randy Lutter, who's at Resources for the Future, also a veteran of OIRA, did a study for the Mercatus Center a couple of years ago in which he and some research assistants went out to try to find every retrospective analysis of a regulation that federal agencies have done where they tried to actually figure out what were the benefits and what were the costs. They found the only agency that consistently tries to do this is the National Highway Traffic Safety Administration. With other agencies, it was pretty darn spotty. And there isn't really a process for revisiting existing regulations, eliminating things that don't work, strengthening things that could work if they were strengthened. There isn't really an organized process for that. Now, interestingly, the Government Performance and Results Act, Modernization Act of 2010 created some mechanisms that could be used to do this. Because it said that for agencies' major strategic goals, the agencies have to articulate, identify every program, tax expenditure, and regulation that contributes toward achieving their principal goals and evaluate the results. The problem is, in order to get that to work, you would need a deputy director, or whatever the title is, a management chief at OMB with a huge amount of clout and backing of the president to be able to tell agencies, if you don't do this, there will be budgetary consequences. And you would need very vigorous congressional oversight to take this kind of information seriously. And what we've seen in the past is that even when presidents try to include performance information with their budget information, committees run by members of Congress from their own party tells them, we don't want to see that stuff. This happened toward the end of the Bush administration. It's documented in a book that we produced on the first 10 years of results from GIPRA. So the end result of all of this stuff is that in the regulatory system, we have a substantial accumulation of things, some of which are valuable, some of which do good, many of which may have dubious value, and very little attempt to figure out which is which. And there's a name for that kind of behavior. It's called hoarding. The Code of Federal Regulations is one of the original locations of hoarders. And here's Patrick trying to avoid having the entire Code of Federal Regulations fall on him. And because of this traumatic experience, he's actually put some thought into how you solve all of these messy problems that Jason and I have just laid out. So now that we've made the mess, I'll turn it over to Patrick to clean it up.